This meeting of the Senate Judiciary Committee will come to order. I've had a point of personal privilege from the senator from New Jersey. The senator is recognized.
Mr. Chairman, I'm so grateful that you give me just a quick, brief minute to express my gratitude for this privilege I've had as a United States Senator to work with one of the more extraordinary staffers I've had a chance to work with in my life. Today marks the penultimate day that Danny Smith will be a Senate staffer. He's moving on to a much more higher paid job. But I do want to say to the committee, we are here often because of the grace and the expertise of our staffers who are often underappreciated, underpaid. But I will tell you, every day that I have been a United States Senator, I have appreciated Danny Smith. He's this incredible combination. He is part Atticus Finch from To Kill a Mockingbird. He is part Lieutenant Daniel Caffey from A Few Good Men, and he can handle the truth. And then he's got a little splash of this cantankerous Chuck Grassley in him as well. So, which makes him just the ideal staffer. I just want to give my deepest gratitude to him. A lot of the big bills that we've done in a bipartisan way here in the Senate, he has been my lead on those. Many of you have gotten to know him, his goodness, his decency, his deep virtue. Today, he's got a number of his family members that are here. I want to especially thank Elizabeth, who has been just an extraordinary part of my staff nonetheless. And if it's okay, with unanimous consent, I'd like to put into the record of this great committee this one senator's deep gratitude for his extraordinary service. And also, even though he's got very tenuous connections to New Jersey, I would like to declare him an honorary New Jerseyan and allow him to have free access to any bathroom on the New Jersey Turnpike. Thank you, Mr. Chairman.
Well, let's have a round of applause for him. Statement with only one omission. There is an Illinois connection, you know.
There is, unfortunately.
Thank you. We have 5 judicial nominees on the agenda today, all of whom are ready for a vote. We have 1 U.S. Attorney nominee, 2 bipartisan bills. The Speak Out Act, sponsored by Senators Gillibrand and Blackburn, and co-sponsored by Senators Hirono, Graham, Blumenthal, and myself. We'll vote on that today. And the Journalism Competition and Preservation Act, sponsored by Senators Klobuchar and Kennedy, co-sponsored by 12 other senators, including from this committee, Senators Booker, Whitehouse, Graham, Feinstein, Hirono, Blumenthal, and myself. This bill is going to be held over. We're continuing to work on it, and we're looking forward to returning to it in a timely fashion. I understand the conversations have been productive since our last committee meeting. I'll make brief remarks about one of our judicial nominees before turning to Ranking Member Grassley, then proceed to votes on the judicial nominees and the U.S. Attorney nominee before turning to the legislation. I want to speak briefly on the nomination of Brad Garcia to the D.C. Circuit Court. Mr. Garcia, accomplished litigator, impressive record of appellate advocacy in the Supreme Court and state and federal courts, drafted dozens of briefs and delivered 13 appellate arguments, including 1 in the Supreme Court, 10 in federal circuit courts. Working at the law firm of O'Melveny and Myers, had a broad, varied practice, represented both Fortune 500 companies and pro bono clients, including many cases of current controversy. As a testament to his skill and his impartiality, the Fourth Circuit also appointed him in 3 cases to serve either as amicus counsel or to represent indigent criminal defendants. Notably, before starting his career as a practicing lawyer, Mr. Garcia clerked for judges appointed by presidents of both parties, Judge Thomas Griffith, a George W. Bush appointee to the D.C. Circuit, and Justice Elena Kagan, an Obama appointee to the Supreme Court. He left a favorable impression at every stop. In a strong letter of support to the committee, Judge Griffith wrote, "Brad knew that I am a judicial conservative, played well his role of helping me to be that type of judge regardless of his views. Brad's integrity and his regard in this regard, coupled with his brilliance, gave me a complete confidence in his work." Judge Griffith is just one of several self-identified judicial ideological conservatives who support Mr. Garcia. He also has the support of Jack Goldsmith, former senior official in the Justice Department under George W. Bush, who wrote that he's great at looking at all sides of the issue. balanced, and fair-minded. Mr. Garcia has an impressive breadth and depth of experience. It's not surprising he received a well-qualified rating from the ABA. He'll make an outstanding judge in the D.C. Circuit. I'm proud to support him. With that, I turn to Ranking Member Grassley.
I'll only vote aye on Judge Douglas and Mr. Blackwell, oppose the others. Judge Douglas has the support of both her home state senators. In an unusual development for this administration's nominees, she's actually answered the question of whether or not she believed in a living Constitution approach to judging. I want to take a few minutes to talk about Mr. Garcia's nomination to D.C. Circuit. He graduated from law school in 2011 and clerked for Judge Thomas Griffiths and Justice Kagan. He also spent a few years in private practice before joining the Justice Department earlier this year. Now, it happens that we had a Trump nominee with very similar years of experience, a person that clerked for 2 prominent federal judges and a Supreme Court justice. Democrats at that time weren't impressed with that sort of recommendation, but they seem to be impressed with a person that has also demonstrated no abilities to serve, quote unquote, on a circuit court. So Mr. Garcia may have trouble getting those senators' votes unless those senators have a double standard. My opposition isn't because of his experience. I have concerns about judicial philosophy, particularly approach to religious liberty. He litigated against Catholic elementary schools, arguing that federal courts have the power to intervene in employment disputes involving teachers responsible for instructing students in the faith. That seems to be interfering in religious freedom. Additionally, we can hold a voice vote on the Speak Out Act bill. I'd like to applaud Senator Blackburn for her leadership on this bill. This is a very important issue, and the bipartisan bill will ensure that victims have the ability to speak out. I will vote yes on that bill. I'd like to also discuss, as you would expect me to, the Justice Department's and FBI's continued failure to respond to our oversight request. Starting May 31st this year, I've written 3 letters regarding political bias that seems to very clearly infected the FBI. 2 of those letters provided specific and credible allegations based upon numerous whistleblowers. The allegations show a deeply rooted political infection that spread to investigative activities into former President Trump and Hunter Biden. Based on allegations, the Justice Department and FBI approved investigative activities into Trump based on in a substantial part on, can you believe it, just liberal news articles and information derived from liberal nonprofit. On the other hand, the FBI shut down investigative activities, which include verified and verifiable information related to Hunter. That activity was entirely separate from the ongoing probe by a Delaware U.S. attorney. The Justice Department and FBI have failed to address the allegations that I've raised. So take notice. DOJ and FBI haven't even disputed these allegations. In light of the FBI's failure to respond, on August 17th this year, I requested a comprehensive organizational chart with the Washington field office. The purpose of this request is to better understand how the Washington field office is staffed and who is responsible for the units and squads within the office. More importantly, it's to prepare for future congressional interviews. The FBI has failed to provide even an organizational chart. What's so secret about that? I don't know. Also, on August 25th this year, Senator Johnson and I wrote to two FBI employees, Nikki Flores, who's the intelligence analyst in charge of the Washington field office, and Bradley Buenavides, who's deputy assistant director within the counterintelligence divisions. Now, these are the very same people that interviewed or briefed me and Senator Johnson August 2020. That's the emphasis briefing that was only done because of Democratic pressure to do it. And I want to tell you, 4 powerful members of the United States House and Senate urged the FBI to brief us in regard to that. And simply put, we didn't learn a doggone thing from that briefing. It was set up so things could be leaked. Certain colleagues on the other side used that briefing to falsely paint our then ongoing Biden investigation as advancing Russian disinformation. Now, you all know that that was a put-up deal because even the New York Times and the Washington Post have said now that we weren't pursuing Russian disinformation. The FBI has failed to respond to our request for information about that briefing. Therefore, Senator Johnson and I have requested that these 2 employees sit for a transcribed interview with us. Now, we've received no response. The Justice Department and the FBI continue to thumb their nose at this committee's oversight jurisdiction. So, we're not going to let up. My work to shine light on transparency in that department will continue just like it would with any department. I yield.
I'd like to make one point for the record. When President Biden took office, he had over 90 U.S. attorneys who had been appointed under the previous administration. All but 2 were replaced. The 2 included the Northern District of Illinois, where John Losh was investigating political figures of the president and my political party. Senator Duckworth and I joined in asking that John Losh continue in this work. The same is true in Delaware, where the U.S. Attorney was retained from the Trump days of administration. And I think it was an effort by the administration, a valid effort, to say that in this delicate moment where there were questions raised about certain investigations, that we would not interrupt the continued service of these 2 individuals.
I applaud the president for doing that, and I think I've said so 2 or 3 times, not only here, but in Iowa when asked about it. But there's one little thing that we're still trying to get information on. When Tebow shut down that one investigation of Hunter Biden, I want to know, does he know about that information? Or does it ever get to him? Because it seems to me it ought to be a part of this U.S. Attorney in Delaware's investigation. I yield.
Thank you, Senator Grassley. Turning to the agenda, first up is Judge Dana Douglas, who's been nominated to the U.S. Court of Appeals for the 5th Circuit. Anyone seek recognition to speak on this nomination? If not, the clerk will call the roll.
Mr. Leahy.
Aye by proxy.
Mrs. Feinstein. Aye. Mr. Whitehouse.
Aye.
Mr. Sass.
The nomination will be favorably reported to the floor. Senator Blackburn has asked for special consideration. She has a conflict with the Armed Services Committee, I believe.
That is correct. They've asked us to come. They're trying to do the photo this morning. So, Mr. Chairman, I'd like to call up my manager's amendment SIL 22B03 and ask that it be adopted by voice vote.
Okay, so we're going out of order to the S4524, the Speak Out Act, sponsored by Senators Gillibrand and Blackburn, co-sponsored by Hirono, Graham, Blumenthal, Portman, and myself. And the motion before us is the adoption of the manager's amendment.
Could you speak up a little? In this corner, it's hard to hear you.
Okay. Before us is the bipartisan manager's amendment filed by Senators Blackburn, supported by Senators Gillibrand and Hirono. Is there any objection? Manager's amendment SIL 22B03. Without objection, the manager's amendment will be adopted.
Thank you, Mr. Chairman. I appreciate that, and I am just so pleased that we are taking up this legislation this morning. I think it is so important to note that 1 out of 3 women will be sexually harassed in the workplace, and the vast number of women have never filed a formal complaint. Further, 81% of women and 43% of men have experienced some form of sexual harassment or assault throughout their lifetime. So this bill will make clear that victims and survivors of sexual harassment and assault should be able to report and publicly disclose their abuse without being silenced by non-disclosure agreements. The bill makes unenforceable any non-disclosure or non-disparagement agreements relating to sexual assault or sexual harassment disputes. And I want to thank Senator Hirono, Senator Gillibrand, and you, Mr. Chairman, for the good work on this issue.
Thank you, Senator. This bill would, in fact, help break the code of forced silence that for years enabled abusers to escape scrutiny and accountability. Senator Hirono is co-sponsor.
Mr. Chairman, I'd like to submit a letter of support from Representatives Frankel, Griffith, and Busto in support of this legislation.
Without objection.
Thank you. I'd also like to, of course, thank all of the advocates, including Gretchen Carlson, who has been such a strong supporter for her work, and AAJ for their support. And of course, I want to thank you and Ranking Member Grassley, co-lead Senator Gillibrand, and Blackburn and Grimm, our House co-leads, and many others for a truly bicameral and bipartisan work on the Speak Out Act. About 1/3 of the American workforce is required to enter into an NDA as a condition of employment. Many others sign NDAs outside the context of employment. NDAs were once only intended to protect trade secrets and proprietary information, but the broad reach of many NDAs has become weaponized by those in seats of power to cover up abuse and sexual misconduct, exploiting the often unequal balance of power between the two parties. These types of NDAs have forced people out of their careers and out of the workforce entirely. This bill will provide survivors of sexual harassment and sexual assault who have signed a pre-dispute NDA with the option to tell their story, because for too long, survivors have been denied the option by people in power, people like Harvey Weinstein, Roger Ailes, and R. Kelly, who used NDAs to cover up sexual assault. The Speak Out Act limits the enforceability of pre-dispute NDAs where sexual harassment or sexual assault survivors want to discuss their experiences and break their silence. The bill covers NDAs between employers and current, former, and prospective employees, as well as independent contractors. It also includes NDAs between providers of goods and services and consumers. The Speak Out Act affirmatively protects trade secrets. It does not preempt state laws that are more protective than those set forth in this bill, setting a floor, not a ceiling, on state protections and preserving helpful state laws. It does not invalidate contracts. What this bill does is it empowers survivors to make the choice about whether to tell their story. The bill also preserves the option for survivors to enter into an NDA settlement if they so choose. And it further strengthens the Ending Forced Arbitration of Sexual Assault and Sexual Harassment Act of 2021 that we passed into law earlier this year. Survivors of sexual harassment and sexual assault deserve better than being forced into silence, and I am, of course, going to work to pass this bill on the Senate floor to make sure survivors can break this silence. Thank you, Mr. Chairman.
Thank you for your, thank you for your leadership, Senator Rono. We have requests for recognition by Senator Klobuchar and Senator Feinstein.
Thank you very much, Mr. Chair. I just wanted to add my support and thanks to Senator Rono and for Senator Blackburn and the others on the bill. I also wanted to acknowledge Gretchen Carlson of my state. I've worked with her family for a number of years, and she's done some really good work advocating, not just for this bill, but other bills in this Senate. And when appropriate, I'd like to be added as a co-sponsor.
Without objection.
Okay, and then one other thing, Mr. Chairman, I want to thank you for your remarks about the Journalist Competition and Preservation Act. We've had incredibly good discussions over the last week with a number of members on the committee, and I feel as positive as ever, and we're getting good thoughts and good ideas, and plan to bring a bill to you for this committee to vote on next week.
Thank you, Senator Klobuchar. And Senator Feinstein, I believe Senator Ossoff also seeks recognition. Senator Feinstein.
Yeah, thanks, Mr. Chairman. As I understand the bill, it would invalidate any pre-dispute non-disclosure agreement if there's a sexual assault or sexual harassment dispute relevant to the NDA. I'm very pleased to ask to join as a co-sponsor. I think it strengthens law in this area, and I would hope it could pass with a very strong vote. Thank you, Mr. Chairman.
Thank you, Senator Feinstein. Senator Ossoff.
Thank you, Mr. Chairman. I ask unanimous consent to be added as a co-sponsor.
Without objection.
And I want to thank Senators Hirono and Blackburn for your leadership and commit to working with you to continue pushing this legislation through the process so that those who have been subjected to workplace sexual harassment or sexual assault in Georgia or anywhere in this country are never silenced by their employment agreements. Thank you, Mr. Chairman.
Thank you. Senator Booker.
Again, I'd just like to be added as a co-sponsor of the bill and just want to thank the extraordinary leadership and work of my colleagues.
Without objection, Senator Cornyn.
Mr. President, Mr. Chairman, I'd ask unanimous consent that I be added as a co-sponsor. I want to congratulate Senator Blackburn, Senator Hirono, and the other sponsors of this bill for a job well done.
Mr. Chairman.
Without objection, Senator Cornyn and Senator Grassley will be added as co-sponsors. Senator Padilla.
Same request, Mr. Chair.
Same request. Senator Padilla will be added. Senator Coons. And so let me just say, as we close and go to a vote, this bill is part of an effort by this committee, which I think will have historic significance. By eliminating the arbitration clauses as a deterrent to people coming forward to make allegations of harassment, by making certain with this bill that the non-disclosure agreements will not have impact on that as well. I think it is going to revolutionize this whole world and, even more importantly, move people toward better conduct because there's going to be true accountability. I want to thank the survivors who've come forward to demand action, including Gretchen Carlson. Thank you for being here to address the injustice of NDAs in the sexual assault and sexual harassment context. And along with the limitations on forced arbitration signed into law earlier this year, we are breaking the culture of silence. I think when we look back on this committee's achievements over the last 2 years, this will be a highlight and should be because it's truly bipartisan. So if no one else seeks recognition at this point, I'll ask unfavorably reporting S4524, the Speak Out Act. All those in favor say aye.
Aye.
Opposed, no. In the opinion of the ayes have it. Majority of the members voting in the affirmative. The bill will be favorably reported to the floor. Now we return to the nominations. Next is Brad Garcia, nominated to D.C. Circuit. Anyone seek recognition to speak? If not, the clerk will call the roll.
Mr. Leahy?
Aye.
Mrs. Feinstein? Aye. Mr. Whitehouse? Aye. Ms. Klobuchar? Mr. Coons? Mr. Blumenthal? Mr. Cotton? Mr. Kennedy? Mr. Tillis? Mrs. Blackburn? Chair Durbin? Chair Durbin, the votes are 12 yeas, 10 nays.
Nomination will be favorably reported to the floor. Next is Judge Francis K. Beam, nominated to the U.S. District Court for the Eastern District of Michigan. Anyone seek recognition? If not, the clerk will call the roll.
Mr. Leahy?
Aye.
Mrs. Feinstein? Aye. Mr. Whitehouse? Aye. Ms. Klobuchar? Mr. Coons? Mr. Blumenthal? Ms. Hirono? Mr. Booker? Aye. Mr. Padilla? Aye. Mr. Ossoff? Aye. Mr. Grassley?
No.
Mr. Graham?
I vote proxy.
Mr. Cornick?
No.
Mr. Lee?
No vote proxy.
Mr. Cruz?
No vote proxy.
Mr. Sass?
No vote proxy.
Mr. Hawley?
No vote proxy.
Mr. Cotton?
No vote proxy.
Mr. Kennedy?
No vote proxy.
Mr. Tillis?
No vote proxy.
Mrs. Blackburn?
No vote proxy.
Chair Durbin?
Aye.
Chair Durbin, the votes are 12 yeas, 10 nays.
Nomination will be favorably reported to the floor. Up next is the nomination of Jerry Blackwell. Senator Klobuchar has sought recognition.
Thank you very much, Mr. Chair. I would say of all the judges I've ever put forward, I feel more strongly about this one than I ever had. He is an incredible person for anyone that has met him. He has 35 years of trial experience, Jerry Blackwell. He founded a highly regarded firm, which has been rated Minnesota's top litigation firm by Benchmark Litigation for 4 years in a row. He was unanimously rated by the ABA as well qualified. He has broad respect in the Minnesota legal community, including from 25 experienced federal prosecutors. And this was something I found out about from his mom after his hearing. He has never lost a case in nearly 35 years of practicing in the civil area. As you all know, he took on the highest profile criminal trial really of the decade by prosecuting Derek Chauvin for the murder of George Floyd. His commitment to public service is incredible. Grew up poor in North Carolina. Brother became a police officer. I really thank the ranking member for his support for Jerry Blackwell and urge everyone to join us. He will make us proud. Thank you.
Thank you, Senator Klobuchar. If no one else seeks recognition, the clerk will call the roll.
Mr. Leahy?
Aye.
Mrs. Feinstein? Aye. Mr. Whitehouse? Aye. Ms. Klobuchar? Mr. Coons? Mr. Blumenthal? Ms. Hirono? Mr. Booker? Mr. Padilla? Mr. Ossoff? Mr. Grassley?
Aye.
Mr. Graham?
I vote proxy.
Mr. Cornick?
No.
Mr. Lee?
No vote proxy.
Mr. Cruz?
No vote proxy.
Mr. Sass?
No vote proxy.
Mr. Hawley?
No vote proxy.
Mr. Cotton?
No vote proxy.
Mr. Kennedy?
No vote proxy.
Mr. Tillis?
Pass.
Mrs. Blackburn?
No vote proxy.
Chair Durbin?
Aye.
Chair Durbin, the votes are 13 yeas, 8 nays, and 1 pass.
The nomination will be favorably reported to the floor. Our final judicial nominee is Ann Nardacci for the Northern District of New York. Anyone seek recognition on this nomination? If not, clerk will call the roll.
Mr. Leahy?
Aye.
Mrs. Feinstein?
Aye.
Mr. Whitehouse? Aye. Ms. Klobuchar? Mr. Coons? Mr. Blumenthal? Ms. Hirono? Mr. Booker? Mr. Padilla?
No.
Mr. Graham,
I by proxy.
Mr. Corning,
No.
Mr. Lee,
No by proxy.
Mr. Cruz,
No by proxy.
Mr. Sass,
No by proxy.
Mr. Holly,
No by proxy.
Mr. Cotton,
No by proxy.
Mr. Kennedy,
I by proxy.
Mr. Tillis,
I by proxy.
Mrs. Blackburn,
No by proxy.
Chair Durbin.
Aye.
Chair Durbin, the votes are 14 yeas, 8 nays.
The nomination will be favorably reported to the floor. The last nomination, we can take a voice vote on Kevin Ritz, nominated to be U.S. Attorney for the Western District of Tennessee. Does anyone seek recognition? If not, on favorably reporting the nomination of Kevin Ritz to be U.S. Attorney, all those in favor say aye. Aye. Those opposed, no. Majority of members present having voted in the affirmative, the ayes have it. The nomination will be favorably reported.
We got requests from Senators Cruz and Senator Holly to be recorded as no on Ritz.
Clerk will note that Senators Cruz and Hawley should be recorded as voting no on U.S. Attorney nominee Ritz. Is there any further business to come before the committee? If not, the Senate Judiciary Committee stands adjourned.